Good morning, everyone. Also, good afternoon and good night to our colleagues that are overseas. Welcome. This is the third event of Law Science, and I'm Vanessa Villanueva. I'm a JSD candidate at the University of Illinois College of Law, and I'm very glad that you all were able to join this event. I will provide a brief introduction of the law science purpose, and we as coordinators thought that legal studies has been generally understood as a discipline outside science and traditionally consisting of doctrinal analysis, right, and debates on normative questions. However, we believe that it can be improved and benefit the scientific methodologies that provide systemic ways to approach questions and deliver falsifiable claims. And so if you want to learn more of our project in law science, someone is going to drop in the chat box our website, and you can also join our mailing list. To that end, I will proceed by introducing our coordinators. So we have Simonson. He is the co-founder of Law Science. We are a group of JSD candidates in the United States. We also have here today, hello, Simon, just say hello to the camera.
Hello, guys. Hello. Thank you, Vanessa.
Then we have Patrick Chonchiawan, who is a JSD candidate from the law school at the University of Chicago. Hello, Patrick.
Hello, everyone. Hi, everyone.
And finally, overseas, we have Daniel Hifke, who is a JSD candidate from Cornell Law School. Hi, Daniel.
Hello, everyone. Hey.
I also want to introduce Kathy Kim, who is a SJD candidate and coordinator at the Graduate Colloquium at Mara School of Law that is joining here today as well.
Hi, everyone.
And I will start with the first speakers, our first speakers today. I don't know if Rubén is already here in the room. I don't see him.
Hi, he's not. Maybe we should start with Ivo if you're okay with
yeah,
that.
Definitely. So Ivo, if you don't have anything against, I will introduce you. So we have today Professor Dr. Ivo Gico that will present an overview of agent-based modeling and the future of law and economics. The floor is yours.
Well, good afternoon, everyone. Thank you very much for the invitation. It's a pleasure to be here with you today to discuss a little bit of methodology in 10 minutes. So as I understand, most of you are SJD candidates and are, of course, struggling to find out a thesis in law. And one of the reasons you are really struggling to find out how to write a thesis in law is because law is not a science. And because law is not a science and there is no theory in law, you are always struggling very much, because sometimes your professors, your mentors might ask you to have a thesis, meaning tell us something new about the world, and you probably cannot. So when you ask me to talk to you a little bit about law as science, the first thing I have to tell you is that law is not a science, will never be a science, because law is not about the world. Law is about a bunch of rules. That's why you studied in your law school a bunch of rules in all areas of human activity and trying to acquire the knowledge on how to operate those rules. Most of you, if not all of you, have no exposition to quantitative methods in law school. You might have it as an optional discipline or from your previous background, but not in law school. And why is that? Because law is not a science. Of course, we can use science to study law. We can use science to study the effects of law, but law school in itself is not a science department. And that might be one of the reasons why you're struggling so much. And I've struggled like you guys in the past. And where I found solace was in something that 20 years ago in Brazil were not really very common, called law and economics. And the reason for that is that law and economics is nothing but the application of economic theory and economic tools to understand legal issues. And that's it, nothing else. So economics actually is a discipline that is trying to behave and work as a science. So they have theories about human behavior. And we use those theories to try to understand how humans behave. And if law is a bunch of rules, then law affects how humans behave. And you have a lot of space to investigate and use economic tools to try to understand legal issues. That's law and economics. And make no mistake, I love it. I love it so much that even after my doctorate in law, I pursued a PhD in economics, so I really enjoy it. And I think that law and economics is smart enough to answer most of the legal issues you might face. It's just fantastic. It's simple, easy to use, and it's actually a theory. But here comes the catch. Vanessa asked me to talk about the future, not the past. That's the past. And the thing is, just like economics, law and economics is still solidly grounded on orthodox economics, meaning basically calculus 1. So what we do, we are trying to understand the whole market. What we do, we imagine a representative agent and create a few equations of how they will behave and move on from this. If we want to do the litigation pattern in our countries, what we do the same thing, and we say that people litigate as long as their expected return is positive. But we never quite really put our hands on what is the actual social system, filled with heterogeneous agents. People are different. And although we might say that on average, all of them or most of them are rational, we are not really sure how they behave collectively. And that's when I invite you and think of my little lecture here as a teaser. I'm just teasing you to look at it, at the literature of the options. And that's when computational social science comes in. An agent-based model is a part of computational social science that is being used a lot in sociology department, but almost nothing in law school departments. And the good thing about computational social science is that they have a few softwares that even us lawyers can easily learn how to use. So it's much easier to learn Mason or NetLogo than R or any other statistical program. And the good thing about computational social science is that we can actually do science without leaving our room. So for example, suppose that Daniel wants to know what would be the best legal rule for our small city. So we have to decide. We want to have as many cars as possible because people want to drive their cars, but we want to know what is the optimum speed that we should use it within our city so that I have a lot of people going as fast as they can. There is a trade-off between speed and the amount of people. Traditional line economics would do some equation models, would optimize and try to figure out that answer. How do we do that? We do it in a different way. We use line economics theory to structure the agents, and we can actually program a small sample of the civilization and let it run to see if the result of the interaction between them is what we expected. And this means that Daniel can now be better informed. We can say ex ante informed of what is probably the best speed limit that we should put into law. So this is one of the very good things about ABM that we cannot do with law and economics normally. Meaning we can do social experiments without experimenting with people. That's a very good thing. What's the limit of this? The limit of this is that, of course, it's a computational system. So it's very simplistic. And in a scientific perspective, it's a theory, meaning I'm imagining that the world will behave somewhere similar to what I'm saying. But the good thing is it's actually science, because I can test it. After we ran the simulations, you can actually take the results, implement it in the real world, and see if it works. And if it works, it's a good theory. If it doesn't work, it's not a good theory. That's called science. And that's very different than most theories that people propose in law, because most theories that people propose having connection with law are not actually theory and are not actually science, because they cannot be tested. And science is about being able to test your theories. If you cannot test it, it's not science. So I'm running out of time, and I'd like to show you very briefly, if I may, 2 examples of how can I do that. Can I share my screen? There you go. Can you see my screen?
Yes.
Great. So here are 2 examples of how we can use ABMs to discuss legal issues. And remember, this is just a teasing. I don't have time enough to go through each model. So at the left is the example that I gave you about speed limit. Here I have a very simple model of streets with lights in the cars, and I can set up my model, and I click go, and they will give me data. Data from your bedroom. Data about how these cars, these drivers, might behave within these given rules. So this is data, this is generated data. You can make your experiment as different as you want. And if you are trying to establish policy, this experiment is better than your intuition, because you might find out unexpected results from this system that you would otherwise not find. So this is just a way to show how can I use it ex ante. Now I'm going to move on very quickly to a more, let me say, debatable issue, so that you can see how I can use it ex post. So suppose that Mr. Sun find out that there are segregated neighborhoods, or that kids, teenagers in high schools are segregated during the lunchtime. And here comes his theory. Oh, people are racist. People are against certain kinds of people. And that's how I explain segregation. Look at the world, they are segregated. But what evidence Mr. Sun has to offer us, except his own intuition? None. This is not a theory. This is just an opinion. We need a theory. And the good thing about the social systems simulated in ABM is that I can show you that segregation can be generated without discrimination. Meaning not that I proved that segregation is not caused by discrimination. I just proved that I don't need it. So it's not a necessary cause. Let me try to show you that. This is the famous Schelling experiment, if you can see at the right of my screen. Suppose you have people from 2 groups, and they don't have any problem with the others, they just don't want to be a minority. So as long as they have 30% of similar people around them, they are fine. Just 30. It's not even 50, 40, just 30%. See what happens when I make the system go. You can see that the percentage of similarity grows up to 75, 73%, and the number of unhappy people goes down. And I generated segregation without discrimination. That is just fantastic. Really fantastic. Why? I didn't prove anything, except that I don't need discrimination to create segregation. So you might be able to use this ex post to test your theories. You create a theory, you can test it using computational systems. So since my time is up, and you might have some questions, I think this is the provocation that I wanted to leave you guys with, and maybe tease you enough to find a few books at Amazon. They're just great. Even I learned how to do it. So I'm sure you guys, brilliant guys, can learn how to do it too. So, Doutoressa Vanessa, that's what I wanted to say today. And I'm more than open for your questions.
Thank you, Ivo, very much for your presentation. I found everything incredibly amazing, and I have tons of questions. But I don't know, how do we want to proceed? Like, probably we are gonna take questions by the end of the presentation. So hold your thoughts for now, and now I'm gonna give the floor to Rubén Méndez, who is gonna present an account of the project that is working with Juan Martín Morando, another of our invitees today, on interactions between informality and employment quality in Argentina, Chile, and Colombia, and Ius Economic Analysis. Rubén, the floor is yours.
So this is a working paper that we have with Rubén. We've been working with it for a couple of months. It takes into account something that's very common in Latin American countries, which is the informality in labor markets. What do we mean with informality? We mean that there are some situations in which employers prefer to keep workers off the books, in order to in some way evade the application of this strong regulatory systems that we have in Latin America. I mean, maybe if you live in
Can you hear me now?
Yeah, we can. Okay.
Juan Martín, just go on with the introduction, then we will.
Okay. So I was on that if you live in the US, you may be familiar with some of the situations. I mean, the regulatory regime in labor markets are really mild. I mean, you have like minimum wage laws, you have like some regulation in collective bargaining, but not very much in regarding the labor contract itself. So this is one of the possible ways of dealing with these issues. In Latin America, we prefer to have these strong regulatory systems. So I left saying to you that in the world we have these two different systems. The ones that depend strongly on freedom of contract, and the ones that absolutely destroys the idea of freedom. And so what we did, I mean, we took our countries, Argentina, Chile, and Colombia, because they are in the same, in the same frame of these strong regimes that substitute parties' wills. And we found that in both systems, we have some advantages and disadvantages. And, mostly in our regimes, the strong regimes, we found that there are plenty of disadvantages. One is that sometimes for parties to comply with everything the law demands for it. And when I say the law, I'm not saying just the regulatory regime of the labor contract itself. I mean, there are a lot of other issues that you can take into account. I mean, I was talking before, you have taxes, you have contributions to the social security systems in our countries are separated ways, not like in America. And we have all this stuff. We have, I mean, like I can give you an example, some of the things that you should have to take into account. If a worker is playing soccer, on the weekend with his friends and somehow breaks a leg, the employer has to pay the salary up to a year. I mean, this is a really high cost, you know. Excuse me, I don't know, there's something. Okay, so when you take away people's freedom of contract, you find yourself in a situation where, okay, mainstream economics would say this can produce unemployment, and this is maybe one of the things that may happen. But in a way, with we were thinking that maybe it's not the real outcome. I mean, informality is one of the outcomes, because what happens is that you take away this employers from the from the how we call it, the umbrella of the law, and you take them out. This is one of the things that happens. This is why we call it informal relations. I mean, there are relations that are above the law in a way. So what we're investigating is what happens with this in this framework, and if you can relate it with the industries in which that demand the labor. I mean, because in labor economics we have this issue that the demand for labor is a very indirect demand. I mean, it depends on what are we going to sell, or what are we going to build, what are we going to do, which kind of labor, or which type of labor we demand. So we were trying to in a way figure out if the market position of any of the employers that demand labor, I mean, in a oligopoly, I mean, in a way that if enterprises have market power, is it the same that if they are competing in a market? I mean, is this the same? Can the outcome be the same? And we tend to think that not. I mean, when enterprises or when employers have a strong power of market power, excuse me, I say it in Spanish, but using the English words. If they have a market power, they'll be able to in a way, you know, pass the cost to others. So maybe in these situations we won't have this informal labor, but the bulk of the employers actually do not have market power. So they, in a way, have to absorb the new costs, and these costs are passed to not to the consumers, but to the workers. So this is one of the things that we were approaching with Rubén, and in a way we were trying to think, okay, what happens if we, in a way, wipe all these labor law principles about same wage for same labor, that in a way, I mean, this kind of principles kind of cut sideways, you know. People say, or tend to think in our countries that, okay, this is a good thing, you know, I can win less than other people, but you know, you can't win more than other people too. So this is one of the things that we were thinking, what if we can, in a way, divide the market among these sort of situations, and, you know, have different regulatory regimes for each of these frames. This is one of the things that we were working on, and this is what we wanted to present to you with all these problems we had. I'm so very sorry about that.
Thank you, Juan Martin, for taking the step on to this presentation that was kind of rumble at the very beginning. And so I don't know if anyone has a question. I will leave like 2 seconds for people stepping up and trying to chime in and ask questions. Otherwise, I'm going to take moderator privileges, because I think that the things that were unwrapped today deserve a lot of discussion, especially Ivo's first few sentences of his introduction. Anyone? All right. So I'm going to start with Ivo. We agree with the things that you have mentioned at the very beginning, but as a movement or as a doctoral association, our position was not to think in terms, law is a hard science, but still is a social science. So what we are trying to do here in the United States, especially the focus on interdisciplinarity, think that it needs to be some sort of cross-fertilization of different disciplines to uncover fact-based matters that will help the legal scholar in order to draw different theories or analyze the law with some sort of base or grounds for the theoretical development. Sometimes, and it's usually happens, as you know, I come from an Italian legal training, so it usually comes the issue that many of the theories do not have any factual background that can be developed, and they are flawed at the very beginning because there is not a need to think about sociology or anthropology or ethnography in order to incorporate that into your legal research. And so sometimes these legal problems just come up baseless, right? And it's not harmful because it encourages the discussion and maybe helps somebody else. But since we are trained to be future legal scholars, we want to understand different type of methodologies that we can incorporate in our legal analysis. So to that end, I agree with you, and here are some of my colleagues here at Illinois that they are struggling with some methodologies such as coding rules and all the stuff, and obviously statistical analysis is very difficult to combine. You were mentioning some of the software that has been used in legal analysis that are very hard to incorporate, such as R. And in my opinion, like I personally use Stata, so that's one of the software for social sciences that it's more, social scientist friendly. But if you're presenting this new way of framing experiments and dealing with experiments without dealing with people, and you also advance the limitations of computational systems, one thing that came into my mind with regard to statistical analysis, even when we use those type of deep statistical categorical analysis or factorial design, it's always between two binary questions, right? Yes or no, so which are at the opposite grounds. And I saw this strong limitation in the use of the legal interpretation because our answers and our questions are never black and white. So I don't know how this new type of software of methodology can improve that.
Now it's my turn, right?
Yes, correct.
Perfect. So the first thing here is that, and I'm going to have to be a little bit philosophical about it, just to make it clear. You guys should know the difference between the is question versus the ought to question. Science is only about the is question, whether something is or not. It's about facts. While law, it's always and will always be about the ought to question. Of course, you need to know facts to implement law correctly, but They are not the same thing. So what I'm saying here is that although law is about human behavior, my statement, and I would love to argue about it, is that there is no legal theory about human behavior. So that's what I was saying, that there is no legal theory about the world. That's why law is never and is never going to be a science, because that's not the purpose of law. Of course, as I was giving the example, once we are doing policy, meaning making a choice, and the first example I gave was traffic, and we're trying to decide which is the best speed limit. We're going to make a choice. Once this choice is made, it will be implemented in a legal rule. And that's the law. The law is the rule. The choice is before the law, not after, not in. It's before. And what I'm trying to show you guys is that you can use computational social systems to make choices when you cannot experiment before. What would be the ideal world to conduct social experiments? Put in speed limits in different neighborhoods, measuring the average limit, the stopped cars, average wait times, etc. Many times in social systems, these experiments are not possible, but still a choice has to be made. How can you make a better informed choice since you cannot make experiments? And assuming you have no data, because you cannot have data of counterfactuals. This is one of the main purpose of these systems. You can do a better choice, an ex ante choice, conducting artificial experiments. This is one. A second is, sometimes you do have data, but you do not have information about the causal relationships that created the data. And here comes the beauty of it. You can create computational systems that will try to create the empirical data that you already have. And by doing that, you can test your theories to explain the empirical data that you have. So what I'm saying here is that ABMs are not a substitute for law and economics, and I'm not saying that ABMs are a substitute to regular empirical science. I'm saying it's an additional tool that can be useful when you cannot conduct social experiments, and is a fantastic tool to test theories when you already have data. So that's the idea. So
Yeah, incredibly.
that will be my answer.
Thank you. It's incredibly fascinating because we, as broke JSD candidates, we lack funding for running real experiments with real people because it's extremely expensive. Because that will help. I'm going to wrap up two questions that are in the chat box. One is from Patrick, our coordinator, and then immediately after Daniel, I'm going to have the questions together so you can give a unified answer. So Patrick is asking how you set feasible assumptions without a normative lens. In particular, you show that 30% of preference can cause segregation without discrimination, but how many percentages constitute a discrimination? And now, Daniel, do you want to unmute yourself and ask your question?
Hey, yeah, sure. So it's a very, very different question, but I think you can make it work. So the questions and direction, I think this talk is titled Law and Econ, Latin American Perspectives, I think. So my question basically is, my limited understanding of the history of law and econ is that it originated in the US and became extremely popular, but now there was a lot of pushback since the CLS against especially rational choice theory, and then there's this kind of law and political economy which is trying to reframe it as more a leftist project. So my understanding is in the US it was like definitely the hegemonic position in law schools for a time, but it's kind of declining now. I know from continental Europe, or at least France and Germany, that it never had this hegemonic position in the first place. So it never really fully translated here. But I also know from my friends, my Latin American friends, that it's very, very popular in Latin America, and that it's, and I was just wondering, how do you make sense of that? So why is it, has it such a strong foothold in one, which is like another civil law system and didn't translate to the other? And also, while it seems, maybe this is the wrong impression, but while it seems to be declining at the methodology, or at least to experience a lot of heavy pushback in the motherland of law and econ, is that different in South America?
Cool. I'll try to answer both questions, and they're quite different, but I will do that. So for Patrick's question, what I'll tell you, Patrick, is that you have a problem of definition. What you are actually asking me has nothing to do with science and the model. You are asking me what would be the definition of discrimination. And for this experiment, when I was using the term discrimination, I was talking about somebody's feeling about somebody else and different treatment of somebody else. That's discrimination. To treat two persons different. In this model, I'm not talking about somebody else, I'm talking about myself. So the definition that I'm using of discrimination here fits the model perfectly. So what you should do is just put a footnote saying, here I'm using the discrimination within this sense, because the importance of the scientific parlance is to communicate, is to understand the other. So when I'm saying that 30% is enough, what I'm saying is that you might have a mild willing to be near people like you, just mild, and that's enough to create segregation. And that goes against many theories that, as Daniel said, is in vogue now, say using discrimination, etc. And I'm just saying that a mild willing to be people like you, a little bit, is enough to create segregation. That is just very interesting. Okay, so I think that might be my answer to Patrick. Okay, so I'm not being normative, I'm giving you a definition. And of course, you can change the slide. That's the good thing about the model. We can change this slide to see if 5% that's enough, 10% that's enough. It's a factual question, and that's science. As per Daniel, you're from Germany? Is that right? Cool. So the thing is, German people are too serious. So when they are doing law, they're very serious about it. They will not make a fuss. So for German people, if I'm not wrong, and I have a few German friends that I love, law is a very serious business. And they make a very clear difference between what a lawyer does and the discussion about law in law school and what a social scientist does. What happened is that in US, first you have a common law, so the judges have much more leeway to choose which legal rule to implement. And second, law schools are not for people who have no other background, meaning law school in US is a graduate course. So you have a lot of social scientists that go to law school. In Germany, you are only a lawyer and you only know hermeneutics, right? That's all you learn in 5 years. So what happened is your assessment of the law and economics movement has some truth in it, but it's not really correct. The thing is, law and economics in US were so successful, that is now embedded in almost every single subject in such a way that you do not need anymore to discuss it as a methodology. So if you have a contracts class, you're going to have some law and economics there. You don't have to stop to study it because it's already in there. If you have M&A, it's already there. If you have almost all kinds of subjects, it's already there. So as we said a few years ago, the future of law and economics is to die as an independent discipline because it will be already embedded in everything else. But the thing I leave you for your reflection, Daniel, is that how can you choose a legal rule as a lawyer if you do not have a theory of human behavior? It is just impossible. You're going to have to use your intuition. And that's what you and people in Brazil and the rest of Latin America have been doing, because we only studied the hard letter of the law. And you're also right that law and economics is a little bit too trendy in Latin America now. And it's the fault of people like Juan, Morando, and Rubén, who keep doing law and economic in a very fashion way. And I think that we can say that they are quite successful. I have to take a little bit of the blame in Brazil myself. But the thing is, law and economics is not a subject, Daniel. Law and economics is a methodology. So at the end of the day, it will not give you an answer. It can only help you find your answer. So, and that's something that I normally have to answer to people and say, well, how law and economics would answer that? And normally I would say, well, it doesn't. It will help you try to find the answer, but it's just a methodology, has no material subject in it. And we can discuss it a little bit more if we have time. Okay.
Thank you very much, Ivo. I don't know, Simon, do you have a question? It's a quick question because we have very few minutes left.
Yeah, thank you, Vanessa. I'm just going to keep it very, very short. And I think this question is kind of like a response to the powerful statement that I've made about law is not a science. And just a quick response to that is that we actually in the group, we did we had a very fruitful conversation about like the difference between is and ought, you know, how do you ask questions, normative question and positive questions, and the fact that that the idea of treating law as science, the law itself is the research process itself, and it's about research and law and trying to learn to ask positive questions instead of normative questions. And this raises to the question I want to ask, which is, what is the role of an academic here, right? So we have lawyers, we have judge, and then we have academics. And so what should academic do when it comes to research? And I know today's theme is about law and economics, and I do agree that law and economic is a methodology. So I was just wondering whether you guys you can share about the role of academics when it comes to law and econ or other methodologies besides comparative research. And I think this is something that we kind of have to that we firmly believe in, but would love to hear your insights or your thoughts, and both to all the speakers today on this question. Thank you.
Mr. Sun, thank you very much for your question. And the answer is very easy. The role of the academic is to think about the law. So the role of the academic is to understand the law as it is and understand the impact of law as it is in the world. So that's the is part of the academic work. And we also have the role of helping policymakers making decisions about what the law ought to be. But for me, it's very clear there is a difference when you say, Ivo, can you please tell me what is the law in Brazil for this? I'm going to have to give you an is answer. In Brazil, the current law is this. It's a completely different question than, Ivo, how is anti-corruption law doing in Brazil? I'm not asking about the law anymore. I'm talking about the impact of the law in the world. So, and because I'm in Latin America, I'm both a lawyer and a law professor. So I do work as both. So when I'm a lawyer, I help my clients understand what the law is so they can make their own decisions. And as a litigator, I try to convince a judge like Professor Juan Morando that my client is right. So that's what a lawyer and a judge do. As an academic, I'm no longer asking myself who is right, who is wrong. I'm asking as much as possible is questions. And I think as an academic, that's what you are all trying to do. And that's why you are all looking for something else outside law school. Because were you to try to answer these questions using legal methodology, you would be desperate, in my opinion.
That's very fascinating. And
If I may add something, something really, really short. I mean,
Yeah.
I think that.
Martín, I just want to add to that question one thing that is related to the thing that you were presenting today, because you were thinking what you were saying, and you are talking to regulators, right? The work that you are presenting today, it's talking to regulators. But actually what I see in the work is that they are only shifting costs from one player to another. Like regulators in Latin American countries usually use private citizens as a mean for the welfare state. And they are shifting this cost in the way that you explain it. Can you elaborate a little bit on this, answering also the question that Simon poses?
Yeah, of course. One of the main things that you find when you try to analyze labor law is that if you try to to look at it in terms of efficiency, you'll find this that you're trying to say. You will find that what regulators do is try to spread the cost of things among a lot of people, and this you can see it also in consumer protection laws. I mean, you can see it there. And here, what it happens is that they produce some sort of world in which the protection of some people produces a cost to others that are left out of the system. This is something that we see. And Horacio Spector, which is a professor from Argentina, and he wrote a paper on the moral foundations of labor law. He says that we shouldn't look at labor law as in terms of efficiency. We should look at in terms of trade-offs. I mean, try to find something good out of something bad happening to others. Here in Argentina, we do this all the time. We have this Aerolíneas Argentinas, which is our flag. How do you call it? Airline. People who pay for it is the people that would never use it. I mean, this is how I see it. People who pay. This is something that I learned with my dearest friend Ivo. People who pay for the use of the legal of the judiciary is actually people that won't use it. So this is something that we are used to. In a way, regulators spread costs among other people. I don't know if this answers your question, Vanessa.
Yes, very much. So thank you, everybody. We ran out of time. And I appreciate all the participants here that were here. Really not with me. You cannot see them because the video is only projecting myself, but we are here. The ones that are virtually, to my colleagues, the coordinators, and obviously our speakers. Thank you, everyone, and have a wonderful rest of your day.
Oh, sorry, Vanessa. Before we leave, I just wanted to final things for everyone. Just please turn on the camera. So we remember later on we have a really good scholars together today. So please, everyone, turn on the camera before you leave. So you guys are ready. So I'll take some shots. Smile, everyone. 3, 2, 1. One more, just in case, everyone. 3, 2, 1. Smile. Yes, thank you so much for allowing me to take the pictures. Thank you.
Thank you all.
Thank you, Juan. And Thank you, Ivo. Thank you, Vanessa. And thank you, everyone who joined us. Thank you, guys.
Have a great evening. Bye-bye.
Thank you.
Bye.
Bye.